You did not follow the proper laws. How he moved out in July? You can't send it to him before he moves.
On the forwarding address, his C looked like a G.
They're asking for double his security deposit because you didn't follow the security deposit law. You're on the oath. Did you attempt to send an itemized list of damages to that address, sir? We're here today on a motion for summary disposition. I did get a request from Mr. Jones to adjourn this matter because of his fine concerns. Did you guys that as well?
Mr. Jones contacted us yesterday about this matter, and it was our understanding that at this point yesterday we were going to proceed with the motion hearing. We did discuss that it was possible we would not be ready for the final settlement conference that was also scheduled for today because we haven't received an answer to our discovery request at this point yet. And so we were understanding that we would proceed with our motion, but perhaps agree to move out the final settlement at this point. So we received some additional documents from Mr. Jones today. We haven't had a chance to review them. We got them at about noon today, but we were able to recognize that it was not fully responsive to our request. He sent us primarily just some photographs, and that was pretty much only responsive to one of the items that we requested.
And Mr. Jones, do you understand the nature of the reason why you're here is twofold today? Basically, they're arguing that you are not entitled to move forward on your case at all because they're entitled to judgment as you did not follow the proper laws according to the landlord tenant laws. And the landlord tenant act, it says that you're supposed to provide Mr. Darren Evans with an itemized list of any damages within 30 days from his move-out date if he provides you with a forwarding address. And I haven't received a response to that. And then in addition to that, they're saying that you are unable to bring an action at this time because you missed the 45-day window that you're supposed to file the action within.
Yes, I don't agree with that, but
You did send him notice?
well, I sent it to his caseworker, which I believe he received through email.
You sent him the itemized list of damages to his caseworker?
Yes, we were going back and forth because Section 8 Ann Arbor Housing they have a program where they were going to cover portion of the damages. April, I think I sent Libby.
This year?
No, last year. He was actually living in the property.
He moves in July. You can't send it to him before he moves.
That's what I'm saying, Your Honor. He was well aware of the damages before he even.
Whether he's well aware, you have to follow the law, sir.
My argument to that is that on the forwarding address, his C looked like a G, and also it's a multi-unit building, and he failed to put the building number on the forwarding address.
Have you all had any discussions at all regarding settlement on this case?
We talked a little bit, kind of vague. Miss Libby, she really couldn't give me I really asked her, like, what is she really looking for? You know, she really couldn't tell me. So
they're asking for double his security deposit because you didn't follow the security deposit law. There's
the inhability, I can't even pronounce it. The inhability, how you say it?
The law says that if you do not return someone's security deposit within the time frame that you're supposed to, then you owe them double. And they're saying that you violated Security Act, Security Deposit Act, and therefore you owe them double.
Okay, well, I reached out to his caseworker.
That's not how this works. You should know that when you go into settlement negotiations, which I'm putting you both in right now, whether Mr. Santa Croce is saying yes or no, I saw his face, but you guys gonna go and talk about this. I'm gonna give you one opportunity, Mr. Jones, to try to see if you can resolve this matter. If you don't, I'm gonna come back and make a ruling on their motion. You should heed what I'm saying right now. Okay?
Okay, so the motion that I requested, that's being denied.
You want me to make a ruling on that right now? I will. Or do you want to talk like I just told you to?
really don't know, tell you the truth.
But you're gonna have to make a decision.
Okay. So if you make a ruling, then we don't have to discuss this, right?
Oh, no, you won't have to discuss it.
Okay. All right. Okay. Well, we can, I guess we can work it out, try to work it out. I don't know. I mean, what all they really want. I know they want double the required security deposit, but that's all she told me.
Talk and see if we can come up with anything. Okay?
Mm. So as far as my counterclaim, that's being denied as well.
Did you just hear what I said, Mr. Jones? If you want me to make a ruling, I can.
Okay.
I'm not gonna keep going back and forth with you.
Okay.
You said you were gonna go make a ruling and now you're back to the same things. We're not doing that.
Okay. I'm not trying to go back and forth with you, Miss Washington.
All right, let's go into the room and have a discussion. All right, Mr. Jones, I think that the part that you're missing is that what we're solely here for today is either a settlement or their argument regarding the Security Deposit Act. Did you review their motion around the Security Deposit Act?
Yes, it was, you got to respond in a certain amount of time, but I mean, I don't think he gave me a valid address. He left off the building number. Cargo looked like Gargo.
So let me make a regarding the request. And this is what I'm gonna do. He apparently is very familiar with the actual motion and arguments behind it. And I will allow him to respond verbally since he has a problem with the reading portion of it so that he can actually provide us with a response. But I don't believe that I need to adjourn it for those purposes, and we can address that particular issue today. And we'll move forward with respect to the Security Deposit Act issue. Having said that, just answer no. You can make your motions on the record so that we can have a record of this in case anything gets killed.
The grounds for this motion are that other than damages, there is no genuine issue as to any material fact, that the defendant failed to provide an itemized list of the damages within 30 days of our client moving out of the property, and then failed again to file a claim within 45 days of our client moving out of the property. Mr. Jones first gave an itemized list of the damages 197 days after our client moved out of the property on July 3rd, 2025. He did this when he filed the claim in January of 2026. He attached the list, an itemized list of the damages. And this is just clearly much later than the anticipated dates by the statute. Mr. Jones still retains the deposit today. And so we believe that he should be found liable for twice the deposit, which would be $2,400.
You did hear him say that the notice provision requires that your client provide a proper address, a forwarding address, correct?
Correct, Your Honor.
And you did hear his argument that the address provided was not a proper forwarding address. Where do I find the address that he claims that was provided, and how did he provide that?
Yes, Your Honor. So you can find the address at Exhibits C and D. Our client provided his address in writing on the day that he completed a final walkthrough on July 3rd on a paper that was specified as like a closing document for the two parties. And then he also provided the address as a text message on the same day, July 3rd, 2025. These are Exhibits C and D.
So in the text message, it says 85 Drive.
Yes, Your Honor. It's the address that he has on his driver's license, and he had no issues in the past receiving mail to that address exactly as written.
Mr. Jones.
Actually, I drove by the 82 ago, and I looked at the building, and there's actually a building number on the property.
Maybe you went to the wrong address because the address is 85.
Yes, 85. It's located in front of Schooner Cove Apartments. I think I was at the right building.
Did you attempt to send anything to that address, sir?
Well, it's possibly it got lost in the mail, Your Honor.
You're not answering my question. Did you attempt to send anything to that address?
to the address.
Please raise your right hand, please, one. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you're on the oath. Did you attempt to send an itemized list of damages to that address, sir?
No, I did. But I did send a list of damages to his caseworker. And he was notified by his caseworker about some damages.
You sent that in April. He didn't move until July. Anything further you want to add regarding your defense to the motion, sir?
I just want to add that Diamond, he broke the lease by doing modifications to the property without getting it in writing from me. You know, he did that on his own. He caused the problem on his own. He hooked up the water line. He called me one day. He said, Nick, my uncle do work. He could hook up this water line. Oh, think about it for a second. I said, as long as we don't have no leaks, D. So I didn't say he could do it, and I didn't say he couldn't do it. I gave him a clause. Down the line, we had some leaks. So I don't feel like I should be held accountable for that because he caused that. He didn't pull a permit. He didn't use a licensed plumber. And that's why we're here today.
Well, actually, that's not why we're here today. Why we're here today is because you didn't abide by the law that said you have to give him an itemized list of damages. If you did that within the 30 days, we'd be in a very different position. Or you have to sue him to retain his security deposit. The law is set up in such a way that you have to follow that, or there are severe repercussions. If you're going to be a landlord, you've got to know the landlord tenant law. You're held responsible for abiding by that. So I in no way, shape, or form agree with somebody's property being damaged or torn up or anything like that. Used to be a landlord myself. But you got to follow the law. And that's the problem here. That you didn't do that. And so now we're here.
Yeah.
And I'm trying to give you an opportunity to try to get this resolved without getting to this point. We didn't do that. So now I'm going to make my rule.
Okay.
You did.
Me and Diamond did have an oral agreement that we wouldn't even go to court.
That's the oral agreement's not going to work in this situation.
I understand.
The motion for summary disposition is granted as to both points. One, he did not submit the itemized list to the forwarding address, which seems to be a correct forwarding address to me. He also did not file the actual claim, the case with the court to make a claim as the security deposit in a timely fashion, and that is great.
We would like to request an abatement of the rent for the year period where the kitchen was in complete disrepair, for the flooring being ripped out, as well as the refrigerator being non-functional and the garbage disposal issue. We have requested documentation related to these matters from Mr. Jones in discovery and have received a few photographs, but no additional documentation on the issues as I've laid them out.
Well, it sounds like we might have an issue of fact with respect to that, because Mr. Jones is claiming that your client was the one who did the repairs.
That's correct. We believe that there is some issues of fact on the actual abatement of the damages to the premises, but that irrespective of that issue, the Security Deposit Act is not affected by who caused the damages.
Your Honor, I suspect what we have is an hour-long bench trial in our future, unless we can resolve this second piece with him, and we're prepared to do that. With the rest of discovery, perhaps we can have some more fruitful discussion to resolve the second half of the claim. There's I think a significant abatement claim, and he's got some defenses, and I hope we work it out. But we can't come to the table because he's claiming things that there should be documentation for, and we're just not getting it.
Right. I'm still trying to grasp a couple of allegations. One, there was there was the refrigerator repair, right? And you were claiming that there was an additional leak that wasn't the refrigerator repair?
In fact, the only leak wasn't the refrigerator.
The only leak was not the refrigerator. So your argument is that it wasn't the refrigerator that created this issue. I see. All right.
Other sides of the room.
I'll schedule it for us. I'll find myself in conference again.